Good morning, Mr. Pretorius. Good morning, everybody.
Good morning, Chair. Chair, in relation to the next witness, there's firstly an application to be brought, and in relation to the next witness, certain logistical arrangements need to be made about the venue from which she will testify, which is a secret location, or an undisclosed location, rather. So until those arrangements have been finalized, which should be very shortly, may we take a short adjournment? We also have Advocate Marani, who is online, who wishes to just make a brief statement in relation to yesterday's evidence and his client, Mr. Jafta.
Yes, good morning, Mr. Morana.
Good morning, Chair.
Yes, you wish to say something about the proceedings yesterday?
Yes, Chair.
Yes.
Chair, you'll recall that at the end of Mr. Jafta's evidence, you called upon me to indicate whether or not I had any re-examination.
Yes.
I responded to that, but apparently nobody could hear me.
Yeah, we certainly didn't hear you. And we assumed I assumed you might have left.
No. I was not going to leave until and unless I was excused. Chair,
yes.
But the long and the short of it is that I did not have any re-examination for Mr. Jafta.
No, thank you very much. Thank you.
And secondly,
yes.
Yeah, if any such technical glitch occurs in the future, Mr. Ndebele is there ably represented.
Okay, no, that's fine. Well, although I said you might have left, it wasn't, I didn't think that you would leave without permission. I actually thought there yes. Might have been just some.
Thank you, Chair.
Yes, yes. So, but thank you for making yourself available just to set the record straight. And of course, you have confirmed that you did not intend to re-examine Mr. Jafta.
That is correct, Chair.
Yes. Thank you very much. And for purposes of today, do you wish to be excused? Or are you going to be with us?
No. I'll be here. I'm actually briefed to represent the State Security Agency.
Oh, okay.
Not the particular. Not the particular witness, but the agency itself.
Okay, no, so you are with us for the whole week?
For the whole week,
yeah.
That is correct.
Okay, no, that's all right. Okay, we are going to adjourn then for a brief period and then resume, but I see there's counsel who wants to say something.
That is correct, Chair.
Yes.
And this is in relation to what was presented yesterday, to yesterday's evidence.
Sorry?
It's in relation to yesterday's evidence. That's why yes. I felt perhaps it's appropriate for me to, with your permission, to
yes.
place the following on record.
Yes.
Chair, yesterday we instructed by our clients to place the following on record. In the morning, we are assured by the chairperson and the evidence lead advocate Pretorius that none of our clients would be implicated by Mr. Jafta's evidence. With that in mind, and the need to mitigate the costs to our clients, we were inclined, and we had indicated to the chairperson that we're inclined to leave the hearing. But thankfully, our clients instructed us to stay for the duration of Mr. Jafta's evidence. Regard being heard to Mr. Jafta's written statement, we understood why the chairperson believed that none of our clients would be implicated in his testimony. The assurance notwithstanding, Mr. Jafta testified that a sum of 125 million rands and assets to the value of 9 billion rands were unaccounted for in the financial year 2017-2018, and he attributed this to projects allegedly carried out of the office of the accounting officer. It is common cause that SSA's budget per annum is nothing close to 9 billion for them to lose that much in a year. This is obvious, and we submit deliberate falsehoods will be rebutted in due course. Understandably, the chairperson was shocked, saying, and I quote, "How could a government department not be able to account for 9 billion rands?" And remarked that, "I have a suspicion that no heads rolled," close quote, and that this money may have gone to people's pockets, implying possible theft. Mr. Jafta agreed thereto. Naturally, we expect the chairperson at the conclusion of the evidence related to SSA to conclude where wrongs have been identified, that heads must roll, and we have no objection thereto. The chairperson even concluded that this money had disappeared and asked if any action was taken against the accounting officer. This implies that even to the chairperson, it was clear that the accounting officer was at that stage implicated in wrongdoing and requiring that action be taken against him. It is easy to determine who the accounting officer during the financial year 2017-2018 was, and to that extent, a certain publication yesterday already wrote that SSA lost 125 million rands without trace during Arthur Fraser's watch, Louis Hotel's state capture inquiry. This reckless falsehood that our client pocketed 9 billion rands of taxpayers' money renders him and his family vulnerable and makes him an enemy of the people of South Africa and therefore a legitimate target in the eyes of many. Even if it was to be accepted, it was not anticipated that by the Commission or Advocate Pretorius that our client would be implicated by Mr. Jafta. It is a submission that Advocate Pretorius could have advised the witness against unprocedurally implicating our client. And this being almost 3 years since our client had left SSA, this was the first time that he heard about such a huge amount of money being accounted for under his watch. Yet, Mr. Jafta, who as a diligent accounting officer had a duty to raise these worrying findings with Mr. Fraser, knew where Mr. Fraser was and did nothing about it. For the record, we have since established that SSA is aware that no access to the value of 9 billion rands are unaccounted for. Similarly, we have been advised that 125 million rands was unaccounted for during 2017-2018 financial year, owing to SSA under Mr. Jafta's leadership, not providing the Auditor General with the supporting documents they had and continue to have in their possession, while they, SSA, conducted what is now clearly a malicious investigation against Mr. Fraser. Evidence in this regard will be led in due course. It would have been prudent, we submit, Chairperson, upon the evidence leader, being a neutral person interested in uncovering the truth, to have at least asked Mr. Jafta if his predecessor was informed thereof. This was certainly not done. The blatant omission fuels perceptions of bias on the part of the Commission or its evidence leaders, especially in the view of the fact that the right to cross-examination of witnesses is not automatic. The above notwithstanding, the Commission, without fail, failed to serve a Rule 33 notice on our client. Take into account that yesterday we were only provided with a copy of Mr. Jafta's statement, which was obviously silent on the offending allegations. We request that, in addition to the statement being provided, we have been provided with that, we request that we be provided with copies of all documents forming the basis of this serious allegation against our client. And we place on record that our client remains committed to the principles of accountability, transparency, good corporate governance, and in view of the above, he recommits himself, as he has always done, to assisting the Commission uncover the truth.
No, thank you, Counsel. It's legitimate for you and your client to raise the matter. Mr. Pretorius, do you want to say something now or later?
If we'd been afforded the courtesy in advance of what my learned friend was going to say, including the serious accusations he makes, one would have thought that it's proper that we be given notice of what he has to say. We will look at it and we will respond in due course. But Mr. Fraser's rights are protected by the fact that he can make any application he wishes to you in a formal sense, and should he be in a position where he needs more time or more consideration before he brings an application to cross-examine, which he may do, to give his own evidence, which he may do, he can rectify the situation insofar, and I make no concessions at this stage, insofar as there's a legitimate complaint, he has his remedies. But only in fairness, as Mr. Fraser's representative seems to insist on fairness, we should be given notice of these matters so we can deal with them properly. Thank you.
Okay, all right. We'll take an adjournment. It's 25 past. It may well be that the logistical arrangements are about to be ready. Maybe it will be a 10 minutes adjournment.
Yes,
but
it shouldn't be longer than that. I'll check now.
Yes, yes.
Thank you.
Okay. We'll adjourn for 10 minutes. We adjourn.
All right.
To unmute, and then if you're done.
Apollo. Confirmed? Yeah. Is it?
Yes, Mr. Pretorius. I see my registrar hasn't put any file here. Yes, Mr. Pretorius.
Thank you, Chair. Chair, the first matter before you is an application made on behalf of Ms. Kay, and indeed by Ms. Kay, to give her evidence from a protected location, and in such a manner as her identity will not be revealed. So it's not evidence in camera, it's just evidence under conditions in which her identity will be protected. Ms. Kay, as you will see from the affidavit before you, is employed by the State Security Agency. She is part of the visa investigation team. She is involved in ongoing investigations of a sensitive nature. And as such, for those two reasons, her identity should be kept confidential. There's precedent for this because Mr. Y, who will become relevant later when we introduce Ms. K, had a similar order given in respect of his evidence previously, and should he return to give evidence, we will ask for a similar order to be given once more. The nature of the evidence that she will give, which is highlighted in the affidavit before you, and the nature of her duties, which are highlighted in paragraph 12 and following of the application, make it clear that her evidence should, in fact, must be given under protected identity. The affidavit also talks of threats and intimidation that have been undergone by the members of the investigation team. Also talk of attempts to interfere with and sabotage the visa investigation. Those are dealt with in paragraph 15. And finally, the regulatory framework demands and regulates the protection of identity of SSA members, and we ask that those be applied. There be no exceptions made. The order that we seek, if I could just give you a copy, Chair.
So the effect of the matter is that, or the grounds for the order are one, because of her status as employed by SSA.
Yes,
and
Chair.
two, that there have been acts of intimidation relating to people working with her or something like that?
Yes, in the investigation in which she is
In the
involved.
investigation in which she is involved. Okay, all right. I see there is counsel who wants to say something. Yes.
Our instructions are to oppose this application.
Is it all of your clients who are opposing?
All of our clients, Chairperson, that are
Yes.
indicated.
Yes.
It is common cause, Chairperson, that we were never informed, or rather provided with a copy of this witness Rule 33 notice. And the rules at 3.3 provides that if a commission's legal team intends to present to the commission a witness whose evidence implicates or may implicate another person, it must, through the secretary of the commission, notify that person, that is the implicated person, in writing within a reasonable time before the witness evidence. 3.3.1, that he or she may be implicated by the witness evidence. 3.3.2, in which way he or she may be implicated, and furnish him or her with the witness statement or portions of the statement. As we stand, we do not have a copy of, we do not have a notice in respect of this witness, and we do not have a copy or portion of a statement. All that we have, Chairperson, is an email that we received on Saturday afternoon. Which said, it was talking about the notice about the witness called Mr. Y. And the letter said, due to unforeseen circumstances, Mr. Y will not be able to testify during the aforementioned period, and it has become necessary for Ms. K, the project manager of Project VESA, to testify in his place. The substance and import of the averments that implicate or may implicate you, because the letter was written to our clients, is the same. It is common cause, Chairperson, that the duty to provide our clients with the notice and the statement is not optional. It is a legislative requirement. The evidence leaders are obliged to provide our clients with this statement. We cannot be ambushed in this manner. To the extent that we are told that Ms. K will be testifying in the place of Mr. Y. Almost, amounts, to when we were growing up watching amateur soccer, where they would substitute a player, and the player that goes out to take his jersey and give the one that's coming in. That cannot be allowed in these proceedings. Rule 3.5 provides that if an implicated person believes that...
Would you complain as a soccer fan that the substitute should be wearing his own jersey, not the other player's jersey?
Well, they're having rules for substitution. but that as well, we may have an issue with, especially if, that yellow team. At any rate, it is common cause, or rather, Rule 3.5 provides that if an implicated person believes that the Commission's legal team did not give him or her the notice referred to in Rule 3.3 within a reasonable time before the witness could or was to give evidence, and that this may be prejudicial to him or her, he or she may apply to the Commission for such an order as will ensure that he or she is not seriously prejudiced. This application presupposes that notice has been given. In this case, none has been given. So we are left with no recourse, really, in terms of the rules. The legal team has no discretion, right, or duty to ignore the rules. And they cannot use time constraints as justification to undermine the rules and our clients' rights. With regards to evidence, we're told it's not evidence in camera, but, well, we are told what the distinction is between what they want to, the evidence leaders want to do now and evidence in camera. We have been advised that, we believe that this is evidence in camera. Rule 4.1 provides that, subject to Rule 4.2, the hearings of the Commission will be held in public. Rule 4.2 says, in an appropriate case, the chairperson may make an order that a hearing be held in camera. In such a case, the chairperson shall specify in the order those persons who will be permitted to attend the hearing in camera. The import of the rule, chairperson, will submit that, as a general rule, hearings must be in public. And this is the argument that was basically advanced by the evidence leaders yesterday when during the application by the minister for the matter to stand down. And similarly, chairperson, on Monday, when we applied for these hearings to be held in camera, we were told that we've got to bring a substantial application. As we stand, we have not received any application. We are an interested party. We should have been served with an application if there's any. To depart from the general rule, we submit, chairperson, that an appropriate case has to be made. Well, we are left to speculate what these intimidations are, by whom. In fact, she's not even saying she was personally intimidated. Just members of the team were intimidated. But at any rate, to the extent that you do not have that application, we cannot even entertain the contents thereof. Rule 9.2 clearly indicates that a witness may apply to the chairperson at least 2 weeks before he or she is scheduled to appear at a hearing to have his or her evidence taken in camera. Well, the impression we have is that this application, if anything, must have been submitted to the chairperson the earliest on Saturday, when we were told that we're substituting. So in the circumstances, chairperson, our instructions are to oppose, one, the admission of Ms. K, to the extent that we have not been provided with the notice, and to the extent, and considering, chairperson, that this would be, well, considering yesterday's witness, the fifth witness, at least in respect of one of my clients, that is testifying without notice. This cannot and should not, this injustice cannot and should not be allowed to persist. It is time that...
Well, the first order that is asked for in the order that has been applied for asked me to condone the fact that no notice is given to implicated parties. So, in other words, there is a clear understanding that on the part of the legal team that the norm is to give notice to implicated parties, but in this particular case, it's submitted that the circumstances justify not giving notice to implicated persons, and that would be dealt with, that would have been dealt with in the affidavit.
Chairperson.
And of course, you know that there are cases, even in court, where a party who brings an application may be justified in not giving notice and has to ask the court to condone that failure. And if the court doesn't condone that failure, obviously, the court insists that notice be given.
Well, Chairperson, you know, a few minutes ago, Advocate Pretorius was complaining about me not having spoken to, at least, you know, the courtesy of letting him know that we are going to read our letter into record. But he's not extending the same courtesy that he expects from us to us. I hear from you for the first time now, Chairperson, that the first prayer that is being asked for is condonation of not complying with the rules in terms of at least informing us. We do not know. We are at a terrible disadvantage, Chairperson. We find ourselves having to respond to serious applications that impact upon our clients' rights without knowing what real application is about and what the reason therefore is. It is my submission, Chairperson, that this is an injustice that cannot be allowed to persist in these hearings. Thank you.
Mr. Pretorius.
Chair, once again, we would have appreciated notice of the content of the application being made now, which the rules require, but be that as it may, I'll deal with it. The first issue is whether Ms. Kay should be afforded the opportunity to give evidence under a protected identity. Full case has been made out for that. Those applications may be brought in the manner that it is brought for the very nature, for the very reason that is contained in the affidavit. That's the one issue. But I think my learned friend goes further. He's now saying that Ms. Kay shouldn't give evidence at all because they have received no 3-3 notice. That is correct. I would have explained that at the commencement of the evidence, but that's a different issue. So perhaps we should deal first with the issue of the protected identity process, and then we can deal with whether she should give evidence at all, which is another application of which we've had no notice. So, Chair, in relation to the latter, I will deal with it after the first matter has been disposed of. Unless you wish me to deal with it.
I think let's deal with both now, since he has...
Chair, the investigators and the legal team have been interacting with employees of SSA, particularly employees who are conducting ongoing investigations of a sensitive nature. Mr. Y is a member of that team, and he was the person who provided an affidavit to the Commission after many months of hard work. He has just emerged from a coma and is quite indisposed, cannot give evidence. Ms. Kay can also give her own evidence, but she is not here to give her own evidence. She's here to confirm what she knows about the statement of Mr. Y. Implicated parties who are implicated by the evidence of Mr. Y have full knowledge of A, whether they've been implicated, and B, the basis upon which they've been implicated. The evidence will not go further than that. So
They were served with Mr. Y's affidavit.
Yes.
Yeah.
So Mr. Y affidavit will be presented to you, and the evidence will be restricted to the contents of Mr. Y's affidavit. That knowledge is shared by Ms. Y. So
effectively, Ms. Y...
Ms. K though, sorry.
Ms. Y is coming to say...
Ms. K, sorry, Chair,
Ms.
that's my
K,
mistake, yes.
yeah, Ms. K is coming to say, I've read Mr. Y's affidavit that has been submitted to the Commission, which is the evidence that he intended to give in this Commission. I know about a lot of matters that he deals with. I have personal knowledge of a lot of matters that he deals with in his affidavit. And I'm coming to confirm what he would have said because I also know it.
Correct.
That's the basis on which he's coming.
Correct.
Yeah, okay.
To the extent that she has additional knowledge, she will not give that evidence if that evidence should implicate any party. She may explain, but not to the extent of implicating any other party. And to the extent that she cannot confirm what Mr. Y has said on his affidavit, she will say so.
Yes.
So the bottom line is there can be no prejudice because every piece of evidence to be given which might implicate a person, 3 notices have been given. It's just we're substituting one concealed identity for another concealed identity.
Yes.
There can be no prejudice arising out of that.
It's a matter of if two people have personal knowledge of the same events,
Yes.
and one becomes unavailable to testify, another one comes in to testify in regard to the same events because she too has personal knowledge of those events.
Indeed, Chair.
And she would go along the lines of the affidavit that was served on the implicated parties.
Yes, Chair.
Yeah.
So there's simply no prejudice
Yeah.
to anybody. And the reason why it has been done this way is that if Ms. Kay was to come and give her own evidence, it would involve a delay that this commission just can't afford.
Yeah. Then you want to say something about not giving notice?
Yes, Chair, that is the practice, that these applications are brought in camera without notice. There's simply no way that we can have an exchange of affidavits which would inevitably involve disclosure of identity.
Yeah, okay. Counsel for various parties, what do you say in response?
And I assume my colleagues as well would also want to respond. And briefly, Chairperson, if what we are told is correct, that Ms. Kay is here to confirm the contents of Mr. Y's affidavit. In fact, you're told that that's basically what's going to happen. We submit, Chairperson, that this is unbecoming. You cannot confirm what is not before the hearing. But again, let me be allowed to finish.
Mr. Kay's affidavit has been submitted to the commission.
Well, but it has no status, at least at the moment.
Yes, well, yeah.
So technically, it is not before the commission.
Continue.
And if the purpose is really to confirm that affidavit, I know we have a problem of time. The chairperson has a problem of time. A confirmatory affidavit should suffice. With regards to...
I think there is a confirmatory affidavit.
No, all I'm saying is submit a confirmatory affidavit. You do not then testify. You see, Chairperson, we cannot backdoor.
You see, this is a matter where the implicated parties, notice is not given to implicated parties because of the nature of the application. But what has happened, as Mr. Pretorius indicates, you have been given Mr. K's affidavit.
Mr. Y.
Mr. Y's affidavit. These alphabets, so one is going to end up getting confused. So basically, Ms. Y is in substance going to say, make an example of a car accident. When that car accident happened, which Mr. Y watched or saw, I also was an eyewitness to it. And I've read his affidavit. And I'm going to confirm what is in accordance with my recollection of what happened. And it is in line to a very large extent with Mr. Y's evidence, but where I differ or where my recollection is not the same as his, I will specify?
Well, Chairperson, our submission is that if they so experience the same things, then there's no need for Ms. K to confirm what Mr. Y saw and experienced. She can submit her own affidavit that deals with those things that...
Maybe confirm is not necessarily... maybe it might be a term that might be confusing to some people. Effectively, she doesn't need to say, I confirm what is said. She can be asked questions based on Mr. Y's affidavit, and she can say, yes, this is what happened, this is what happened, this is what happened. But I don't think that, saying she shouldn't say confirm really, she confirms really adds much in terms of substance. She claims to have personal knowledge of the same matters that Mr. Y deals with in his affidavit, and therefore she would not be giving hearsay evidence.
Well, Chairperson, the word confirmed is introduced by the evidence leader. So,
yeah, I'm not blaming you for it.
We must then follow what they are saying. But the reality, Chairperson, is we submit that Mr. Y's evidence cannot be introduced via backdoor. There is always a possibility that Mr. Y can decide that, no, I am not proceeding with this affidavit. He may, for whatever reason, want to distance himself from the contents of that affidavit. Hence, I say, if they saw and experienced the same things, then there is no reason why we do not, first, Ms. K's affidavit has to be aligned to Mr. Y, and two, why she is not submitting her own affidavit explaining all the things that she recollects. There is no reason. The reality is that we are trying here to justify failure to comply with the rules. And that, Chairperson, should not be allowed to happen. People's lives are being affected here.
I'll give you, are you done or do you need more? You are done.
I'm done, Chair.
You are done, thank you. I heard that there might be somebody else.
Chairperson, we just want to place it on record.
Chair, if my learned friend wants to place it on record, perhaps he should speak into the microphone.
Yes.
Chairperson, we just want to place it on record, just like what my learned colleague has done, and to notify Chairperson that on the 24th of January, we wrote to the Commission, legal team, objecting to the evidence of Ms. K, or Ms. K coming to give or to confirm, as the Chair was saying, the affidavit of Mr. Y. Chairperson.
Well, I was clarifying that maybe confirm is not the right word, because she has personal knowledge, as I understand it, of the same events.
Yeah. Chairperson, just like what we do, we extend courtesy every day to the legal commission, to the legal team of the commission, with my learned colleagues. Yesterday, we extended the courtesy of trying to engage the legal team in terms of what is it that Ms. K is coming to do today. And then we were told by members of the legal team that she's coming to confirm. So we want to place it on record to say, just like what we did yesterday when we started, that should it happen, as we've seen now, my learned colleague has raised, that the client, his client was implicated. Now, should it happen that another client, our client, or my learned colleague's client is implicated, then how do we move forward in terms of that issue? Are we going to say, are we going to accept what the witness has said, or are we going to now be placed at a position wherein we need to review
You will be given an opportunity after to respond to her affidavit or to apply for leave to cross-examine her. That is what has happened in matters such as this, where this kind of application is done, and a number of them have been brought and granted on that basis. You may have noticed from the media some time back that there were witnesses connected with Transnet who gave evidence from a secret location dealing with evidence about certain people that they said were collecting bags of money from the Gupta residence. Same thing was done. Same thing has been done with other witnesses who have given evidence from a secret location. You get, the implicated persons get the opportunity after to refute the evidence. The norm is you get the evidence before, but there are exceptions. It's just like in court, as I indicated to your colleague. The norm is if you are going to bring an application for an order against somebody, you serve the application on that person so that when you move that application in court, that person is represented and is able to oppose. But there are circumstances where the court departs from that. The implicated person doesn't get given notice, and the person who brings the application asks the court to condone that for reasons that are given. And if the court is satisfied, then it gives the implicated party an opportunity afterwards to deal with the allegations. That's the principle.
Yes, I hear Chairperson, but Chairperson, can Chairperson agree, or I don't know, is it too much for us to say it is common cause that Ms. K cannot come to the commission and give evidence to the commission on an affidavit that is disposed by Mr. Y?
Yeah, you see, you are all getting confused with something that really is neither here nor there. You know, I'm saying, as I understand the position, Ms. K is saying, in effect, to a very large extent, take this affidavit by Mr. Y as if it was my affidavit, because I have personal knowledge of the contents of that affidavit. I'm going to come and testify about exactly those things. But where my recollection or my knowledge differs from that of Mr. Y, I'm going to say so that no, my recollection is different. But though a lot of things that are there in that affidavit reflect my own knowledge.
No, Chairperson, I think the confusion would have not even been there if the legal team of the commission is willing to engage. Like I pointed out yesterday, the legal team of the implicated people. And that it is a matter of time. It is a matter of us agreeing that after this presentation of the commission of whoever witness is there for today, just like what Chair suggested yesterday, that maybe we stay for an hour, address the issues of the witness that is coming tomorrow. When Chair goes home or later on after the commission, is at a position of knowing all these issues that we will be raising here today. And then that will make this commission's life very, easy. But now we are faced with a situation where in every morning we must do ground check, we must do housekeeping, which is not acceptable. And at some point we even withdraw ourselves to certain issues because we are learned colleagues here and we must treat each other with respect. And indeed, we try to do that. And we cannot go to the public and behave like people who don't have ethics. We can't do that. That's my submission, Chair.
Yes, no, thank you very
Chair,
much.
can I just respond, please?
Yes.
Correspondence that has been addressed to the Commission has been responded to. There have been engagements. But the evidence of a witness, the circumstances under which a witness gives evidence, is not a matter of negotiation between that witness's representatives and the legal team. These matters are for you to decide. Evidence will probably be placed before you, and they can respond. Quite frankly, the notion that we must negotiate whether a witness gives evidence and the conditions under which a witness gives evidence and what the witness can and can't say is just nonsense, Chair.
Yeah. I think there's another counsel who wants to say something.
Yes, Chair. My learned colleague has asked me to stand down for him to come first.
Oh, okay, all right.
Thank you, Chair. Mine is rather a comment rather than... Rather to oppose the application as brought by Mr. Pristores,
Yes,
because we understand that and the extent upon which our client has been implicated. We find comfort as well to say Ms. K will only be confined to what she understands based on the fact that she's been involved in the investigation as she will then lead and be led. However, the discomfort that we have, as much as some undertakings were made in previous witnesses to say you are not implicated, therefore you did not receive the Rule 3 notice. But when the evidence leader, in the course of leading the witness, then certain people are implicated, and it was brought to our attention, I would only, on the instructions of my client, find comfort if I could hear that Ms. K's evidence is only going to be confined insofar as it relates to her involvement with Mr. Y's evidence, which is under oath. Those are my submissions, Chair.
well, what Mr. Pretorius has said is that she will not go outside the affidavit of Mr. Y. And she will not give evidence, her own evidence, insofar as it relates to matters that are not dealt with in Mr. Y's affidavit. So in other words, when you look at Mr. Y's affidavit, that's what she will confine herself to,
Let's assume,
as I understand the position.
without debating, Mr. Chair, it's just for clarity, let's assume there are certain aspects Mr. Y would rather, Ms. K would rather not go to because she would not be confident to give such evidence. Can we have an indication from the legal team whether Mr. Y at some point, having disposed at the moment, will come and testify to some of the aspects of his statement, so that when we get an opportunity to respond to some of the issues, we'll respond meaningfully rather in a piecemeal fashion. Those are my
Okay.
submissions.
Okay.
As soon as Mr. Y recovers, I don't know if my learned friend heard, Mr. Y has recently emerged from a coma.
Yes,
He
yeah.
is seriously indisposed.
Yeah.
It is nothing that I can give any guarantee about.
Yes, yes.
And my empathy goes towards Mr. Y. He will come if there is space on the calendar, and he will come if you decide, Chair.
Yeah.
It's a matter in your hands. I might just add, it might help my learned friends, that indeed Ms. K has prepared an affidavit, which will be put before you, annexing Mr. K's affidavit. To the extent that she cannot confirm what Mr. Y says, she will say so.
Yeah. Was there another counsel?
I've just received instructions from my clients. The information that we have is that the evidence team has known for quite a while that Mr. Y had been ill and in hospital. So it is not something that's new that came to their attention now.
But they might
So
have,
they could have,
they might
they've had
have
enough
thought
time.
he would recover in time for the hearing.
They've had enough time to, at the very least, submit or give to us a Rule 33 notice that talks to Ms. K, and they elected not to.
But the substance of what Ms. K is going to testify about, is in Mr. Y's affidavit. You know it.
But Mr. K, Ms. K is not
All you have been told is,
Mr. Y's alter ego.
all you have been told is, instead of Mr. Y saying these things in this affidavit, Mr. Y, it will be Mr. K. The substance of what will be said about your client or whoever is there. It's been given to you, you know it.
But Chair, that's ignoring the rule. The rule says, give us a statement or an extract of the statement. It does not say, give us someone else's statement upon which you rely.
Yes, well, Mr. Pretorius, I think if he hasn't dealt with that, he will deal with that. I think, let me hear, I think there was another counsel who wanted to say something.
Thank you. Good morning once again, Chair. Mine is more on what the Chair has been referring to and referencing, at least to the practice in the courts. And to the extent that I understand what the Chair had said, that it is a norm, and possibly I understand the Chair saying it is a norm in this commission. May I refer the Chair to what is commonly the rules applicable here? And my learned colleague, I didn't hear, because my colleague from the state, or the commission rather, has requested that we deal with this application in separate, despite the fact that you then directed. There is, I would want to confine myself to what is the application brought to you today, and to what extent that application should be opposed and how it should be brought. My learned colleague has pointed out that 2 weeks notice, which is in terms of Rule 9.2, should be given to, and reasons should be provided to you, Chair. And the rules, therefore, enjoins the Chair to then exercise his discretion. But it doesn't do so as a wide discretion, because the rules at Rule 11 then provides for general applications that will apply vice versa to the Commission and to the participants in the Commission. May I then direct, with permission of the Chair, to Rule 11. I will probably want to read selected provisions. Rule 11.1 says, any party wishing to make any application to the Commission which is not otherwise provided for in the rules must do so on at least 7 calendar days' notice in writing to the Commission, but the chairperson may condone non-compliance with this notice on good cause shown. That, I accept, Chair, is what we are guided by the rules even in court. Now, I have heard the Chair saying that there is a norm, or at least a practice in law, that such application may not be served. However, Chair, the rule of this commission directs at 11.3 and 4 and 5, says whenever these rules make provision for any person to apply to the commission or the chairperson, the application must be substantive application on affidavit with a notice of motion. The affidavit must, among things, reflect the relevant facts and the order sought and the grounds. And this is what we understand has been provided to you today. However, then it goes on to say at 11.4, the application must be lodged with the Secretary of the Commission, who will ensure that the original is delivered to the chairperson and a copy to the Commission's legal team. This will also apply in reverse. I will want to think. The applicant in that application must cite every person whose right, emphasis, every person whose rights may be adversely affected by the order sought, and serve, emphasis, a copy on him or her. And that's where I take issue, Chair, because my learned colleague's argument on particular at this point is that we have not, and to the extent my learned colleague has accepted, that they have not complied with the rules insofar as 3.3 notice of why is concerned. Not only that now, there's a transgression further, that we are not even given a notice, at least 7 days from them knowing of this. What we have been given was an email that was given to us. And I would, to the extent that my memory serves me well, it says, please note that we will be substituting, reference to my learned colleague. And this individual will just confirm what Wise says. I've tried to look at Wise's statement as the deliberations were going. That nowhere in Y where he then, as my learned colleagues professed, that Y will almost be to the similar status as, or K rather, will be in a similar status of Y. Where Y then deposed to say, I will want protection, and I want my testimony to be in camera. So until today, there was no such intention, or at least given to us, that we will be applying, at least know that we will be applying to have this testimony of a substitute player in camera. Now, having taken what the chair has said, that this is the norm, but my submission will be that we are guided by the rules, and the rules therefore provide that in as much as there could be these challenges and these applications, a party that is interested and which we seem to be all in agreement that we are indeed implicated, directly so if we are now to leave to the premise that K is going to substitute and to an extent confirm the affidavit of Y, which we then received the notice and spells out that we are indeed implicated. So now, will that therefore justify not being given the application in advance, or at least being served, because the Rule 11.4 provides for same, and that we then apply ourselves, because it says specifically that it must be in a notice of motion, affidavit accompanied. So the notice must be served on any interested party, so that they can therefore be able to exercise. My gripe, therefore, Chair, is on non-compliance on the very same application now that you are now faced with. Because then the rules otherwise then says on practice direction that the chair will give direction in exercising his discretion. That's my submission, unless there's anything, Chair.
Thank you very much. Registrar.
Renaka.
Mr. Pretorius, what do you say to that?
Well, Chair, in the first place, it seems that the intention to preclude Ms. K from giving evidence in camera should not be confused with the intention to prevent her evidence at all. Quite simply, the Commission must hear the evidence in our submission. It's important evidence. But in relation to the application for protected identity, the rules make it clear, and as all rules, they're there for the convenience of the court or the Commission, not in order to obstruct due process and to prohibit the Commission from doing its work. it makes no sense for my learned friends to insist that an application to give evidence in camera or an application to give evidence under conditions of protected identity should not itself be brought under the same terms. What my learned friends are asking for is an application in the name of the witness concerned, giving full details of the witness concerned so that they can contest it. One can't conceal the name till you've given an order that that is so. And that's what we've asked you to do. It's perfectly logical. It's within this practice, and it's perfectly within ordinary practice to do that.
Well, Ms. K has brought an application.
And she brought the application long ago, Chair. before you,
Yes.
as did Mr. Y.
Yes. Yes. I've heard what various counsel who have spoken have said. I am going to grant the application, and if they wish me to finish reasons for the decision, they may request reasons, and I will provide them.
As this is the chair.
Yes, thank you. I'm satisfied that the application should be granted, and insofar as any rule may not have been fully complied with, I'm satisfied that in all of the circumstances, condonation should be granted. Now, in terms of the actual order, I shall make the following order. 1, it is recorded that this application was heard without prior notice to affected parties, and failure to give notice is hereby condoned. 2, having had argument presented by Mr. Pretorius, the head of the Commission's legal team, and having also had counsel representing some of the parties, I make the following order. That is now 2. 1 was, it is recorded that this application was heard without prior notice to affected parties, and failure to give notice is hereby condoned. 2 is what I've just read, and the order is 2.1. The witness is to be referred to during her evidence before the Commission, and after her evidence insofar as the Commission is concerned as Ms. K. 2.2, the witness identity shall not be disclosed or published in any manner. 2.3, the names and initials of the witness shall be redacted from all affidavits and documentation presented in evidence. 2.4, no photograph or video or other image of the witness may be taken or published or broadcast. 2.5, no person may photograph or publish any photograph or other image of any person engaged in and or responsible for the protection of the witness when she gives evidence. 2.6, the witness need not be present at the Commission's hearing venue when giving evidence, but she may instead give her evidence from a separate and undisclosed location in brackets, the protected witness location. 2.7, no camera will be permitted in the protected witness location. 2.8, no person other than the chairperson, members of the Commission's legal team, the Commission's safety and security advisor, those necessary to assist or protect the witness when she gives evidence, or another person specifically designated by the chairperson will be permitted to enter or are permitted to enter the protected witness location unless they have prior written permission, the prior written permission of the chairperson of the commission. 2.9, it is recorded that the oath has been administered to the witness in front of the chairperson. 2.10, an audio link from the protected witness location will be provided so that the witness evidence can be heard in the Commission's hearing venue when such evidence is given. 2.11, subject to the usual rules applicable to the conduct of the Commission's proceedings. 2.11.1, members of the public, including the media, may be present in the hearing venue in such numbers as may be directed by the chairperson. 2.11.2, sound reaching the hearing venue via the audio link from the protected witness location may be broadcast, and the proceedings in the hearing venue may be filmed and broadcast. 2.12, this order may be amended or supplemented by the chairperson at any time if, in his opinion, that is necessary to protect the applicant or the witness or any person in connection with the applicant or the witness evidence, or to ensure fairness to any implicated person. 2.13, in order to protect the identity of Ms. K, the Secretary of the Commission was authorized to sign the notice of application on her behalf. 2.14, this order shall also apply with the necessary changes required by the context should the witness be directed to give evidence. No, 2.14, Mr. Pretorius, doesn't seem to be necessary.
It doesn't apply, Chair, in this case.
Yeah, it shouldn't have been there. So 2.14 is not going to be there. So the order goes up to 2.13. That is the order.
Yes, 2.14 was only there should the Commission revert to virtual hearings.
Yeah, okay.
Thank you, Chair.
Okay. Thank you.
I'm not sure what the Chair wants to do about the short adjournment, or should we just proceed?
Yeah, I guess maybe we should have a short adjournment so that when we start, we go up to lunchtime.
Yes, Chair.
Yeah. Let's all have a 15 minutes adjournment. We adjourn.
For us.
Okay, let's continue, or let's start.
Thank you, Chair. Ms. Kay, can you hear us?
Yes, Advocate Pretorius, I can.
Thank you. Ms. Kay, would you look at the bundle before you?
By the way, just
Yes.
to repeat, the oath has been administered to the witness.
Yes. You confirm that, Ms. Kay, that you have taken the oath?
Yes, I do.
Thank you. Ms. Kay, would you please look at the bundle before you,
Yes,
marked SSA Bundle 02,
yes,
and go to the divider YY9.
yes.
If you go to
Uh,
page 340, and we're referring to the black numbers in the top left-hand corner, you will see an affidavit.
Sorry, Advocate Pretorius, is it, you said YY?
So YY9, the last divider in that file.
Okay, yes,
Do you have it?
yes, I do.
All right. Please go to page 340.
Yes, I'm there.
Do you see there the affidavit of Ms. Kay?
Yes,
And if you go to page 341, the signature has been removed, but this oath was taken, or not the oath, rather, the affidavit was attested to on the 26th of January 2021. Is that right?
yes, that's correct.
This is your affidavit.
Yes, sir.
And annexed to your affidavit, as Annexure K1, is the affidavit of Mr. Y. Do you see that?
Yes, I do.
And if you go to page 418, you will see that that affidavit was attested to on the 30th of November 2020.
Yes, that's correct.
Thank you. Just by way of background, Ms. Kay, you and Mr. Y, amongst others, are employed by the SSA and are involved in the conduct of investigations or an investigation.
Sorry, Mr. Pretorius.
Sorry, do you want to admit the...
No, hang on. Is page 418 the last page of Mr. Y's affidavit? No, I'm not asking the witness, I'm just asking Mr. Pretorius. It appears to be.
He's going to ask something else. Sorry,
You noticed
Chair,
what I've noticed?
I'm getting advice. I'm receiving advice from several quarters. I'm distracted.
Okay, is page 418 the last page of Mr. Y's affidavit?
419 is the last page.
Yes,
which has the signature of the Commissioner of Oaths.
Yes, no, you are right. It looks like to me, it may be that there is something at page 418 that shouldn't be there, or am I mistaken?
That is a pseudonym.
Oh, Oh, okay, okay.
It's a pseudonym that has
Okay.
been placed across all affidavits by the investigator. It's a pseudonym in addition to Mr. Y.
Oh, okay,
So
well,
he's-
that confuses.
Yes, it does, and we'll
Because-
correct it, Chair.
Because we should either have the pseudonym that is written there at page 418 or Mr. Y, and not
Yes.
both, yeah.
Correct.
Yeah,
You're absolutely correct. We'll correct that, Chair, but
yeah,
if one goes to page 343, you'll see that the pseudonym says also known as Mr. Y. So pseudonym A, also known as
Yes.
pseudonym B. It
Oh,
gets very complicated, but it's there, and we can,
yeah.
we
It's
can tidy it up.
explained. Okay, I may have missed that. It's just that also, I think it's better to have one, whether it's Mr. Y or.
No, you're quite correct, Chair. We will stick
Yes.
to Mr. Y.
To avoid confusion. Okay, all right.
Yes, this world is confusing enough as it is.
Okay, you may proceed.
Yes. Ms. Kay, are you there?
Yes, yes.
Both you and Mr. Y have been involved in Project VESA, is that correct?
Yes,
Right. And you have worked together for a period of time in the course of that investigation?
yes, Chair. I don't know if I should clarify the working together part.
Yes, please do.
I cannot say that we worked together because Mr. Y is not a member of the team. He is rather a co-sponsor of the project. So he was getting high-level sort of reports, just like the sponsor of the project. So he was not a member of the team, and I needed to clarify that because the work that we did, he did not really know if the day-to-day running of the project.
All right. You worked together with him on the project, though. In other words, he was the
Yes,
sponsor of the
with-
project on which you worked.
Co-sponsor, yes.
Yes,
Because there
co-sponsor.
was another co-sponsor and a sponsor. I'm the project manager.
All right. Okay. You
Am
needn't refer to your
I'm sorry-
position.
I'm sorry, Mr. Pretorius. Well, yes, Ms. Kay, as you give evidence, just always be alive to not saying anything that could make you identifiable. You understand
Okay.
that? Yes, yes. And that's
Yes.
why Mr. Pretorius says you need not mention your position.
Okay.
But am I correct in understanding that what the distinction you seek to make between yourself and Mr. Y is that you were involved in the actual operations, but he was receiving reports about those operations?
Yes, Chair.
Okay, all
All
right.
right. Yes, Ms. Kay, I'm trying to put the propositions to you in general terms so that the precise nature of your position is not disclosed, which would make it easier to identify you. So if you would just bear with me.
Okay.
Let's put it this way. Both you and Mr. Y have had continuous interactions in relation to the work of Project VESA,
Yes, we have.
and you've shared knowledge.
Pardon?
You have shared knowledge concerning
Yes,
the
we do.
activities of the project, correct?
Yes.
And save for exceptional circumstances, which we will refer to where relevant, whatever he knows about the workings of the project, you know. Is that correct?
Yes.
And as we go through his affidavit, which is annexed to your affidavit, where you don't know or have no knowledge of what he says, you will tell the chair. Is that correct?
Yes, I will indicate.
So when you deal with or attest to what Mr. K, or Mr. Y rather, says in his affidavit, you will have your own personal knowledge of that fact. Correct?
Yes. Yes.
And given the proceedings of the last 3 days and the nature of the evidence you're giving, its sensitive nature, may I ask you please to be very cautious not to implicate any person other than those who are mentioned in the affidavit of Mr. Y. There will be times when you will give your own comments, but provided you do not implicate any person other than those implicated in the affidavit of Mr. Y, that would be in order.
Yes, I understand that.
Thank you. Chair, may we admit exhibit YY8, sorry, YY9 onto the record?
Well, that is Ms. K's affidavit.
And next to Ms. K's affidavit is Mr. Y's affidavit, and it forms part of that affidavit for that reason.
Yes. And her affidavit will be exhibit.
YY9.
The affidavit of Ms. K, which starts at page 340, together with its annexure, which is the affidavit of Mr. Y, is admitted as exhibit YY9.
Then, Ms. K, you have before you another bundle of documents. It's called SSA Bundle 01. Do you see that?
Yes, I do, Chair.
You will testify in due course, as I understand it, that the Commission issued a request for information to the State Security Agency for certain information and documentation. 3 lever arch files were provided to the Commission pursuant to that RFI, the request for information. Those 3 bundles rather contained documents and information which had been declassified by the Director General, the Acting Director General. Is that correct?
Yes, it is.
For convenience sake, we've compiled a single bundle comprising those 3 lever arch files, and that's marked bundle 01, exhibit YY1.
Yes.
These are documents which are relevant to the investigatory work that Project Vesa have done. Am I correct?
Yes, they are.
They contain documentary evidence which confirm much of the evidence that you and Mr. Y will give, and that has already indeed been given.
Yes.
Should I have bundle 01, Mr. Pretorius?
Yes,
Or not
the
yet?
document comprises, if you would bear with me one moment, some 886 pages. Chair, I'd ask that that be admitted
Yeah, okay. Let
as
me have it first.
exhibit YY1. It's the reference bundle.
trying to make sure that we are not going to do something that will be confusing. For quite some time, what we have been doing is to refer effectively to the file as bundle and the documents inside as exhibits. Of course, we have got SSA bundle 01 on the outside on the spine, which is fine. But I think you have in mind that I think it refers to exhibit YY1.
Yes, Chair. Otherwise, we would have 886 separate.
I realize, of course, what can be done is yeah. It's
If it assists,
Well,
Chair, we can refer to it as Bundle 01.
yeah, maybe we should maybe we should just refer to it as bundle 1, SSA 1, SSA bundle 1. And
Also known as Exhibit YY1.
but what is quite clear is that in bundle 01, SSA bundle 01, there are various documents
Yes,
that have evidential value
Yes, Chair.
that are going to be used.
Yes, Chair.
I see there is YY. Oh yeah, there is YY1.
Chair, if one looks inside the bundle
Yeah,
01, you'll see an index.
yes,
And so the documents or groups of documents to which we will refer,
yeah,
each has its own marking.
yes. Is that the Q and A and B and C? Is that what you are referring to?
It's on page 2.
Yes, I'm looking at page 2.
It's marked index.
Yeah,
The various documents are grouped under heading 1, and then from heading 2, 3, 4, and 5, documents relating to particular projects are listed.
yes.
We won't be referring to all of them, but some of them.
Well, I think let us say each document, I guess, has got some kind of heading that identifies it.
Yes, Chair. We will guide you through as we go through.
Yes. I wonder whether at least those that we will refer to, we can't, as we come to them, use the heading, say it's exhibit YY1 that or something like that. Or would that still be quite cumbersome?
Yeah, for record-keeping purposes, Chair, it is probably better that the documentation be collated under one heading,
Yes.
and then we refer to page numbers.
Yes.
For reference purposes, that will be much easier than going through the bundle looking for a particular heading.
Yes.
So the sequence of pages is important.
Could we say that effectively the exhibits the documents are all Exhibit YY1,
Yes, Chair.
but there are different documents under YY1, and you have to identify the page where they
The
are.
page and a description of the document.
Yes, yes. Okay, all right. This file then will refer to it as SSA bundle 1 or bundle 01, and then the documents will, for convenience, be Exhibit YY1, and each document will be referred to with reference to the pagination and the heading of the document. Is that
Thank
fine?
you.
Is that fine?
Yes, Chair. Thank you.
Yes. Okay, all right. Thank you.
Ms. Kay, can I take you to
Yes,
the
Chair.
affidavit of Mr. Y? And just
Yes.
for clarity's sake, you will tell the Chair what you, of your own personal knowledge, can testify to in relation to what Mr. Y has said in his affidavit. Correct?
Yes, that's correct.
And where you cannot, from your own personal knowledge, testify to what Mr. Y has said in his affidavit, you will alert the Chair to that fact. Correct?
I will.
You do have added information which may implicate other people, but that information you won't present today or tomorrow. That information will be presented in due course in a separate affidavit. Correct?
Yes, I understand.
Thank you. If you would then go, please, to paragraph 2.1, under the head Cooperation with the Commission.
Yes, I can see that.
Do you have knowledge of the fact that the SSA, and in particular the Director General, received a request for information from the Commission?
Yes,
Right.
I can confirm that.
Yes, and can you confirm that in that request for information, the SSA was asked to provide information with regard to the SSA's investigation into irregularities within the Chief Directorate Special Operations?
Yes, I can confirm that.
And do you know, in your own knowledge, that a number of reports, presentations, assessments, in fact, a number of documents were handed over to the Commission in response to this request for information?
Yes, I can confirm that.
Do you also have knowledge of a summons being issued by the Commission dated the 26th of August 2020, requesting certain materials from the Commission?
Yes, I
From
am aware.
SSA.
From the SSA by the Commission, correct, Chair, thank you. And do you know that further materials were produced in response to that summons?
Yes, I do know that.
And subsequently, further requests for information were issued by the Commission to the SSA, and they were responded to.
Yes,
In paragraph 2.4, there's an assertion by Mr. Y about where these documents relevant to your investigation were found. Do you know that they were found during an inspection in a walk-in safe at the SSA?
yes, I do know. I can confirm that.
This doesn't implicate anyone, so I want to ask you, were those documents lodged there in the normal course of administration?
I'm not certain.
All right.
I'm not certain.
All right, you
Yeah.
needn't go further.
Pardon? Sorry?
You needn't go any further in regard to that. There will be further evidence if it's necessary. But what I do want to ask you is the documentation provided to the Commission in response to the requests for information and summons were handed over, and then during a long process were declassified for the purposes of making them public. Is that correct?
Yes, that's correct.
And those are the documents contained in the bundle that the Chair and I have just been discussing, Exhibit YY1, Bundle 01. Is that correct? That bundle before you?
Yes, that is correct.
Paragraph 2.6, Mr. Y says that the documentation provided to the Commission was also handed over to the Directorate of Priority Crime Investigation on 10 June 2019. Do you have knowledge of that?
Yes, I do.
It was also handed over to the Investigating Directorate, ID on the 15th of October 2020, correct?
Yes,
And
that is correct.
this was done pursuant to 2 inquiries opened by the SSA on 10 April 2019 in terms of the Prevention and Combating Corrupt Activities Act. Is that correct? Do you have knowledge of that?
Yes, I do have knowledge of that.
Right. Now, in paragraph 2.7, the origins of Project VESA are described. In paragraph 2.7, reference is made to an internal investigation of the SSA, I presume, called Project Momentum. Do you know of that?
Yes, I do know of it.
That project was initiated as an investigation, an internal investigation to address allegations of corruption within the SSA. Is that correct? Do you know that?
Yes,
Right. And we are told that limited progress was made in that investigation because of challenges experienced in relation to access to information. Is that also within your knowledge?
yes, it is.
The investigation, the affidavit continues, was therefore reinforced and relaunched by the acting DG, Loyiso Jafta, on 5 December 2018 under the name Project VESA.
Yes,
You confirm that, do you?
yes, I confirm that, Chair.
Right. And the mandate of Project VESA is described in paragraph 2.8. The investigation team was tasked with investigating irregularities and criminality arising from the contravention of the SSA's governance, operational and financial prescripts during the period 2012 to 2018. Do you know that?
Yes, yes, I do.
Right. The affidavit continues to say that the investigation has focused on various units within the SSA, chiefly the projects carried out by the CDSO, that's the Chief Directorate Special Operations, which is defined earlier, as the covert operational structure within the SSA, but also the cover support unit and operations run from the office of the DG. Do you know that? And can you
Yes, I do know
state
that.
that from your own knowledge? Sorry, I interrupted you.
Yes, I do know that, Chair.
The method or methodology adopted by Project VESA is described in paragraph 2.9 as multi-phased, multidisciplinary. I presume that means in other words, an all-encompassing approach to the investigation. Is that correct?
Yes, that is correct.
And its vision is to assist or to attain a sustained institutionalized clean governance culture within the SSA. Do you know that?
Yes, that is the vision.
Right. Mr. Y deals with his own experience there, but I presume you know him to be a person of experience within SSA.
Yes, I do.
He says in paragraph 2.10 that he, that's Mr. Y, is giving the evidence contained in this affidavit on behalf of the Project Vesa investigation team. You are aware of that, I presume?
Yes, I am aware.
It continues to say threats have been made against individual members of the investigation team by certain implicated parties. Do you have knowledge of that?
Yes, I do. Although not direct, but I do know of that.
We needn't mention any names at this stage. It should further be noted that several individuals, including implicated persons who have been assisting our investigation team, have also been intimidated. Do you have knowledge of that, whether direct or indirect?
Not direct, but there has been reports to us.
Made to the team? The investigation
Yes, by some of the people that have cooperated with us.
Right. And finally, the statement is made in paragraph 2.10 to the effect that there have been attempts to interfere with and even sabotage the Project Vesa investigation. Do you have knowledge of that allegation?
Yes, I do. I do have knowledge of that and experienced it myself directly.
Really? All right. Perhaps we can put the detail of that in a supplementary affidavit and deal with persons involved in that regard. If we can move on to paragraph 2.11, please.
Yes.
The statement is made that this affidavit, that is the affidavit of Mr. Y, deals with the creation and unlawful operations of a parallel intelligence structure within the SSA and the financial irregularities that accompanied it during the period 2012 to 2018. Do you know that?
Yes, I do know, Chair.
However, some of the activities, the affidavit continues, reflect a continuation of the irregularities that accompanied the implementation of the Principal Agent Network PAN program during the period 2007 to 2010. Both the PAN and Project Vesa investigations uncovered the unlawful use of parallel intelligence structures to bypass internal controls and avoid accountability for gross financial irregularities and abuses of SSA resources for improper purposes. You will testify to those issues in detail, but at a general level, are you comfortable to assert that as being within your own knowledge?
I would accept that with a caveat that I don't have detailed information on the PAN. However, based on reports that I read, I could indeed see the similarities in terms of modus operandi in certain instances.
Thank you. Paragraph 2.12 deals with the structure of the affidavit, and that is a convenient summary of the contents for the reader of the affidavit. We will be covering all those topics, so we can go through to the introduction over the page. Paragraph 3.
Yes.
For the sake of completeness and to place the evidence that is given in this affidavit and that will be given by yourself into its proper context, you have set out, and Mr. Y has set out in this affidavit, certain constitutional principles. And just like to highlight them in summary for the sake of context and completeness. Paragraph 3.1.1 refers to section 198C of the Constitution, which stipulates that national security must be pursued in compliance with the law, including international law. I'll go on because no one can contest that this is what the Constitution says. Section 1995 reinforces this imperative. The security services must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. Paragraph 3.1.3 says, no member of any security service may obey a manifestly unlawful order. 3.1.4 reads, national legislation must regulate the objects, powers, and functions of the intelligence service. You are obviously aware of those provisions. Is that correct?
That is correct, Chair.
Paragraph 3.2 sets out that the constitutional principles are consistent with the White Paper on Intelligence of 1994. Evidence in that regard has been given by several witnesses, and we don't need to deal with that in any detail. Paragraph 3.3 refers to two statutes. The first is the Intelligence Services Act 65 of 2002, which has been amended several times, as you will know, particularly in 2013, and the National Strategic Intelligence Act. Those are two pieces of legislation governing the South African intelligence services. Is that correct?
Yes, that's correct, sir.
And then reference is made in paragraph 3.4 to the counterintelligence mandate, but we needn't go there. That's part of legislation which no one can dispute. Provided it's constitutional, of course, I must correct myself. If we can go to the following page.
You are right in, because what you are saying is no one can dispute, that's what it says.
Yes.
That's what it says. Whether it's constitutional is another thing, but you are talking about what it says.
Yes, correct.
I think you are right.
Yes.
I interrupted you.
Yes, whether it binds the SSA, of course, might have, but perhaps we needn't deal with those subtleties, at least at this stage, but we may have to, given the events of the past week.
Okay.
And in fact, Chair, to be serious, there is a contention which may be raised in submissions that there may be some contradictions or conflicts between the 2013 amendments to the Intelligence Services Act and the Constitution.
Yes.
But that is a matter for later consideration.
Okay.
If we can go over the page, please, Ms. Kay, to paragraph 3.5, which deals with the organizational and governance structure of the SSA. And the point is made that political responsibility for the SSA lies with a duly designated Minister of State Security, and the governance structure of the SSA falls under the leadership of the Director General, in this case the Acting Director General, correct?
Yes.
Then certain comments are made in paragraph 3.6, and I don't think we need to deal with it today in relation to the role of the Minister of State Security, but they're there for the record, and I don't wish to ask you to comment on that. In paragraph 3.7, there are some internal documents, some of which remain classified, some of which we have. There are the MPDs, that's the Ministerial Delegations of Powers and Direction of Payment. Is that correct?
Yes, that is correct.
and several operational directives referred to in paragraph 3.7.2.
Yes, the operational directives.
Yes, so
Okay.
do I understand correctly that the activities of the SSA are governed in detail by various regulatory instruments, which may be termed internal instruments? Is that correct?
Yes, that is correct.
Right. Let's go on to make some high-level observations, if we may, in relation to the evidence that has been collected by the Project Vesa investigation team. Now, as I understand the position from what you have told us, Ms. Kay, that you in particular have working knowledge and direct knowledge of the evidence, documentary and otherwise, gathered by the investigation team. Is that correct?
Could you please repeat that?
That you, as a member of the investigation team, the Vesa investigation team, have knowledge of the evidence collected by the investigation team, the documentary evidence and other evidence that the team has collected. Is that correct?
Yes, I have knowledge of that.
Right. And the conclusion is drawn by Mr. Y in paragraph 3.8 that the team has established, or it has been revealed to the team, that the operations run by the Chief Directorate Special Operations fell outside the lawful mandate of the SSA, did not follow prescribed procedures, and totally ignored the applicable governance, financial, and operational directives of the SSA. That is a comment at a high level. It's generalized and perhaps it's absolute, but can you attest to that yourself, or do you wish to qualify it in any way? And by qualify, I
Yes,
mean...
I'd like to just indicate that for me, I don't think this means that it's all the projects, because we don't know the entirety of the picture, but most of the projects that we analyzed and the documentation that we analyzed showed exactly what Mr. Y indicated in 3.8.
Right. And then in 3.9, it is stated...
I'm sorry, Mr. Pretorius. Ms. Kay.
Yes, Chair.
What you have just said, does it mean that you are saying you are not in a position to say the entire CDSO fell outside the lawful mandate of SSA, but you are saying you are confining yourself to those operations of CDSO that Project Vesa has been investigating?
Yes, Chairperson.
Okay, all right.
Thank you. Then paragraph 3.9 continues. It says there that the unlawful intelligence operations, well, let me repeat that. It says unlawful intelligence operations and front companies were used to siphon funds from the SSA and create parallel intelligence capacities, which, if not abated, would have continued to pose a risk to national security and the constitutionally established state. That general comment, do you associate yourself with it?
Yes, I do, Chair.
And it continues to say these unaccountable intelligence structures extended to parallel procurement services, vetting, counterintelligence, VIP protection, and domestic operations. Is that statement correct?
Yes, it is.
It continues to say the implicated members or former members used their positions of authority to ensure that they or their family members or close associates directly benefited from unauthorized contracts with front companies and/or illegal operations. As a general statement, without implicating any particular person, is that an accurate statement?
Yes, it is accurate, Chair.
Paragraph 3.11 makes a further general conclusion that the structures of the CDSO, presumably subject to what you said that you were investigating, were used to further political ends by drawing political heads into the security space. I'm not sure precisely what Mr. Y means there, but we could ask him in due course to explain if he comes. And by undue interference in the political process. Can you say whether you agree with the statement, at least insofar as it says structures were used to further political ends by undue interference in the political process?
I cannot wholly confirm this assertion, save for one instance, which I don't know whether it's political interference, but what I could gather from one of the implicated individuals during an interview was them admitting to taking money to fund the Protect Luthuli House campaign. That she indicated that the money was used to bus in people from KZN who were purported to be MKVA members, and the SSA paid for their accommodation, food and transportation. So as for the rest, I don't have the evidence, because the investigation itself was, and the conclusions thereof, are based on evidence, things that I could analyze and actually gather, and as well as the team, in terms of analysis and evidence that we could actually analyze. Yeah.
You're speaking to evidence which has been before you in documentary or by way of, in documentary form or by way of oral evidence, of which you have, to that degree, direct knowledge. Am I correct?
Yes.
Insofar as the matters you have just spoken of form part of a project which we will deal with later, we will deal with it later, will we?
Yes, I think we will, and maybe I'll comment further when we get there.
Thank you. The remainder of 3.11 and 3.12 are matters that we can deal with from a legal point of view, but 3.11 does say this political interference, and certainly the political interference you know of, is in contravention of the SSA's mandate and the constitutional prescripts relating to civilian intelligence structures. Do you associate yourself with that statement? Obviously, you can't talk of political interference of which you have no knowledge, but the political interference of which you do have knowledge. Yes.
Yes, in general, yes, I agree.
Right, and then paragraph 3.12 talks of three categories of person covered by your project's investigation, or the Project VESA investigation. That is the initiators, persons who conceive and direct illicit or illegal operations, and we'll deal with those in the documentation in due course. Facilitators, persons who execute those operations under the direction of superiors, and primary and secondary beneficiaries. that may fall into various categories. That's an analytical statement. I'm not sure that it requires any comment, but if you have any comment, wish to confirm it, you may.
My only comment is that this illicit value chain is very important in the sense that it shows how organized and orchestrated some of these activities seem to have been based on the evidence that we have.
Right. And we will deal with that in detail when we deal with the evidence regarding the various projects. Do I understand you correctly?
Yeah.
Right. If you'd look at paragraph 3.13, and you would bear with me a moment, please. If you would look at the names in that paragraph, and before we put that paragraph on record, just say whether
Yes.
you know that the allegation regarding that individual is a fair allegation or correct allegation from the knowledge that you have, not what Mr. Y has, in the course of obtained in the course of your investigations. Just have a look there, and then just read out the contents of paragraph 3.13, if you would, to the extent that you can confirm it.
To a large extent, I do agree and confirm what is reflected there on 3.13. Although I do want to acknowledge that some of the individuals mentioned here, actually their involvement was at varying levels. And also there are other individuals that are not actually listed here, who obviously I believe played a very critical role.
All right, well, just name those that played a critical role in the matters that you investigated, and not others that you don't feel sure about.
Could you please repeat that?
Mr. Pretorius, make it clear. Your question may be understood as if you are inviting her to include those who might not be mentioned in the paragraph that she knows to have played a critical role. I don't think that's what you intend.
It's not what I intend at all,
Yes.
Chair. And perhaps I should clarify and repeat, as Ms. Kay wants me to do. Do you see there in paragraph 3.13, a number of names are recorded? Please just mention the names that you, from your own knowledge, are satisfied played a critical or important role in the matters investigated by Project VESA.
In other words, Ms. Kay, as I understand it, what Mr. Pretorius is saying is that he notes that you have already said that you are largely in agreement with what Mr. Y says in paragraph 3.13, and he notes that you have said there are other names that are not mentioned. One, he wants you to confine you to the names that are mentioned, but I think he wants you to mention only the names in respect of whom you have personal knowledge of their involvement, but only names that are in the paragraph. He doesn't want you to introduce names that are not in the paragraph.
Yes.
But you mention those in respect of whom you have personal knowledge of their involvement by virtue of the information you obtained through the investigations that you are busy with. Mr. Pretorius, did I capture that correctly?
Ms. Kay, do you follow what I've tried to convey and what the Chair has conveyed?
The chair was a bit inaudible in some parts, so I didn't catch most of what he said.
Okay, let me repeat. As I understand it, Mr. Pretorius note that you say there are certain names which are not included in paragraph 313 that you think maybe
Can't
should...
hear the chair.
Oh, okay. I think I'll have to bring my mic closer. Can you hear me well now?
Yes, yes, Chair.
Okay. One, I think he doesn't want you to mention any names that are not in paragraph 313. You understand that?
Yes,
Even though you
Yes.
may think that those other names which
Okay.
are not here also played a role, okay? That will be dealt with some
Yes.
other time. You confine yourself when you mention the names in paragraph 3.13. You confine yourself to those names that you have personal knowledge of as people
Yes.
who were involved in these things based on your involvement in the VESA investigation. You understand?
yes, I do, Chair.
Okay, all right. You can then continue.
Yes, could you mention those names, please, that you're satisfied played a role or were involved in matters investigated by Project Beza?
Okay, the first one, maybe I should just read the paragraph.
Yes, read the paragraph insofar as what you are able to confirm. Okay.
Okay.
Read it, yeah.
At an executive level, the abuse of the SSA in its mandate occurred primarily under the political leadership of Ministers Siyabonga Cwele, David Mahlobo, and Advocate Bongani Bongo, and was executed or implemented primarily, although not exclusively, by Mr. Moruti Nosi, Ambassador Tulani Dlomo, Ambassador Sondo Kujo, and Mr. Fraser, Alpha Fraser.
Right, thank you. Chair, it's 1 minute to 1, about to start a new topic. Would this be a convenient time?
Yes, we'll take the lunch adjournment and we'll resume at 2 o'clock.
Thank you, Chair.
We adjourn.